Hello everyone, thanks for joining me here today. Lane Neves is happy to offer this webinar on NZS 3910 2023 to help you understand the contract and navigate it as we all begin to work with it. My name's Jackie Frampton and I specialise in construction issues and disputes, and looking forward to talking to you today about this new contract. We've had a lot of interest in the contract and in the webinar, and so we're pleased to have had a good response. You're obviously all really interested in hearing about the contract and how it's going to work now that it's beginning to be used in the market. So 3910 2023, what I'm going to talk about today is why has it been updated, what's really driven the need to revise the contract, what are the key changes, and I'll go through some of those with you. I'm also going to talk about considerations when using the revised contract and what you need to do once you start to work with it. So the previous revision of 3910 was, of course, the 2013 version, so it was around 10 years old. There'd been a number of changes in legislation since then that needed to be incorporated into an updated contract. And there was also a feeling within the construction sector that some other changes and updates needed to be made to better reflect how the contract should be working. And I also note that 3910 doesn't stand alone. It's actually part of a set of contracts. There's a number of them. They're all slightly different, but they basically use similar principles. And 3910 is the first one in the set to have been updated. So I guess the other contracts will be updated at a later date, but that hasn't occurred yet. So 3910 2023 is the fourth and latest revision. It's published by Standards New Zealand, and what it is it's the conditions of contract, the general conditions of contract for building and civil engineering construction, and the 2023 version was published in November last year. It's a head contract, so it's a contract between the head contractor and the principal, and that's what it's suitable for. So it's not a subcontract and it couldn't be used for that. And what it is it's a standard form of general conditions for incorporation into a construction contract. One of the issues that was arising was that parties were incorporating really extensive special conditions. So they were making extensive amendments to the general conditions of contract. And one of the reasons for the 2023 revision was to try and reduce the number of special conditions. So Standards New Zealand says that 3910 accounts for around 80% of the construction contracts written in New Zealand. But when they say that, I'm pretty sure that they must be excluding a lot of residential construction, because it's not a contract that would be suitable for, say, a principal who was a residential homeowner. But it might be suitable for, say, a developer who was building a block of apartments. And so it's designed to be suitable for most projects most of the time, but of course a lot of projects will have special requirements, and so that's why the need for special conditions arises. And of course the contract's not perfect. It's not going to be perfect for every principal or every contractor, and a lot of parties will have their own special conditions that they want to incorporate into the contract terms. An important innovation with the 2023 revision is that you can now actually edit the general conditions of contract. So how the contracts worked previously is the general conditions, you haven't been able to edit them. So you end up with the general conditions of contract that you can't make any amends to physically, and then you have a separate special conditions of contract. So what that means is that you've had to flick between the general conditions of contract and separate special conditions which amend the general conditions either by adding additional clauses or deleting some of the general conditions of contract or otherwise modifying them. And it's made the contract actually quite difficult to read sometimes, because you have to flick between the general conditions and the special conditions. Sometimes that can be hard work, especially if you're dealing with some quite meaty clauses and having to look at a lot of different clauses. and terms as well. So to be able to edit the general conditions of contract to incorporate the special conditions, it's going to make the contract a lot easier to work with, and I think it's well timed that that happened. So I'll just talk a bit about the process for drafting the new contract. So a committee was set up called the P3910 Conditions of Contract Committee. And so that was made up of 23 people nominated by various organisations, and they represented a range of interests. So there were people from central and local government, various principals, private sector, and of course contractors as well, and also consultants. And so the idea of the committee members representing a wide range of interest was so that all of those parties could put their points of view forward, because of course there's no point having a contract that contractors are really happy with if principals don't want to work with it. So the committee members have incorporated a whole bunch of different ideas. They've come together and shared them and hopefully come up with a contract that will generally be acceptable to most parties. During that revision process, a draft contract was released last year for comment, and there was feedback from more than 2,000 submissions were given on that contract. So it's fair to say that there's been heaps of interest from within the construction sector, and plenty of people have an opinion and wanted to have a say about the new contract and what it should and shouldn't incorporate. Hopefully the end result is a contract that's generally going to be acceptable to a range of parties and is generally fair. In terms of the purposes of the revision, according to Standards New Zealand, they wanted a contract that was widely accepted and fit for purpose. And also a key goal here was to reduce the need for special conditions. Some parties were wanting to have extensive special conditions to amend the general conditions of contract. Some law firms had templates of special conditions that were many, many pages long, and it meant that negotiating the contracts could take a long time. It could be very expensive, and then of course the contracts were very lengthy to read. The idea of this 2023 update is to try and reduce the need for special conditions and have a contract that's more likely to be acceptable by different parties. And of course, if that goal is successful, then dealing with the contract should be much more efficient and take less time to negotiate. Another key goal was to try and allocate risk fairly. Particularly contractors have been quite keen to limit their risk in some ways, and so that's another focus of this revision as well, is to have a fair allocation of risk. And another goal has been to try and embody a more collaborative approach, so encourage the parties to work together and reach agreement where they can, rather than always resorting quickly to dispute resolution processes. I think that's a really admirable goal. I'm not 100% sure if it's going to be successful, and I also think it's really interesting that this more collaborative approach that the new contract is supposed to embody is coming in at a time when, for a lot of parties, they might be under some financial strain, or the economic conditions are quite uncertain. And sometimes when there are those sorts of conditions, parties can be a bit more aggressive. They don't always want to take that collaborative approach. They want to sometimes try and take a more aggressive approach to get as much money as they can. So I'll just be really interested to see how this more collaborative approach that the new contract is supposed to represent plays out in those kind of tougher economic times, and whether it succeeds or whether it's just a little bit too hard right now. There's a number of points in the contract where the parties have to try and agree certain matters, and as I go through the key changes, I'll highlight what some of those are. So that's really about that collaborative approach that the parties are supposed to be taking more of under this contract. There isn't actually a clause in the contract that overall tells the parties that they have to try and collaborate and work together in good faith. Rather, there's specific points in the contract, for example, with variations and extensions of time, where the parties have to try and reach agreement, if at all possible. These sorts of clauses are quite hard to enforce because what they really say is the parties have to try and reach agreement if they can, and it's really hard to force parties to agree. They really just have to make a genuine effort to agree, and beyond that, there's not really much that can be done to try and enforce those clauses. So they're really more about showing the intention of the parties rather than being clauses that you can really enforce. So I'll now go through some of the key changes that have been incorporated into 3910/2023. I'll start off with the order of precedence. So this is included in the contract agreement, so right at the start of the contract. So the contract agreement includes a list of the contract documents, and obviously that's a really important thing to include in the contract, is which documents are actually included in it. So previously, under the 2013 version, there was no order of precedence. So that meant that the contract didn't specify which documents ranked ahead of other documents where there was an inconsistency. And so with a construction contract, the contract documents can easily stretch into the hundreds or even thousands of pages when you include the drawings and the specifications and the other documents that make up the contract. And when you're dealing with that sort of volume of documentation and quite complicated subject matter, from time to time there are going to be inconsistencies, and so it's important that the contract sets out how those inconsistencies can be resolved. And so what's been common when people are drafting special conditions to contracts is to include an order of precedence, so to set out how the contracts rank ahead of the others. And usually what the contract says is that the list of documents in the contract agreement, the ones higher up the document, they will outrank the lower ones. So the ones up the top will be read ahead of the ones down the bottom in the event that there is an inconsistency. And so the contract agreement now incorporates that clause. So it says that the documents higher up the list, they outrank the lower ones where there is an inconsistency in the documents. So that's good. That's a clause that the parties now don't have to add in themselves because it's already in there. Parties do need to be a bit careful about this, particularly for contractors, because the contractor's tender is near the bottom of the list of contract documents. So that means if the contractors have tags or other requirements in their tender documents, if they want those documents to be incorporated into the contract and overrule anything else that could be in the contract documents, they need to ensure that those requirements are actually incorporated into the special conditions or else in post-tender documents that are higher up the list. So that's just something for contractors in particular to bear in mind. And there's also been a reverse in the order of drawings and specifications in the list of documents. So drawings take precedence over specifications. Previously, they were in the opposite order. In terms of the contract price, so the existing options have been retained. So there was lump sum, measure and value, and cost reimbursement, and as you'd expect, they're all still in the contract. There's also a new contract price option, which is the target price option. And there's also now the possibility of having a combination of all of the different items. So you could have some parts of the contract lump sum and some cost reimbursement or some target price or measure and value. The parties can specify in the special conditions if they want to have a mixture of the contract price options. I'll also talk about target price. So this has only just been incorporated into 3910. Although it's not new to the construction sector, it has been around for a while, but it just hasn't been in the general conditions of 3910. So the principle is that the parties share in the risk or the cost savings. So how it generally works is they agree a target price, and then the contract cost is calculated as per the cost reimbursement basis, which is already set out in the contract, and then there'll be adjustments for other matters allowed from the contract. So there'll still be adjustments for things like variations or extensions of time. and then any cost savings or cost overruns are shared between the parties in the proportion stated in the specific conditions. So I guess this is about this risk allocation thing, if the parties sharing the risk or sharing the benefit if they want to. Because this is a new option, I guess parties have to be careful if they want to use it. The contract is not particularly detailed about how this all works. So I think if parties do decide they want to explore this option, they need to have a careful think about it, and probably seek advice as well about how all the details are going to work, and consider if any amendments to the general conditions are warranted to set out in more detail how this would all work. And obviously it's quite a change, this potential cost saving or cost overrun, in terms of who bears the risk as well. A really important change that's been made to the contract is the engineer to the contract role has now been removed, and instead that's been split into two. So the engineer to the contract previously played a dual role, so they wore two hats. On the one hand, they were the principal's agent for certain actions, and on the other hand, they also had to act independently and make a whole lot of decisions under the contract. And there was always an inherent tension in this role, because on the one hand, they were acting for the principal when they were wearing one hat, but when they were wearing the other hat, they were an independent and fair decision maker, making decisions on a whole range of key issues under the contract, such as payments, variations, extensions of time. And there was a feeling within the sector that perhaps this role wasn't always working well, and that a lot of engineers weren't necessarily understanding the role, or weren't perhaps acting as independently as they should have been. And in particular, a lot of contractors have been dissatisfied with the engineers and had a feeling that perhaps some of them were favouring the principal. And there are some particular reasons why that could occur, because principals are likely to have more construction projects in the future and to need to appoint further engineers for those projects. The engineers were perhaps going to want to keep the principal happy to get more work off them in the future. And in some cases, the engineers were even employees of the principal. And so, of course, in that case, the engineer is not going to be truly independent if they're an employee. And the principal also pays the engineer as well. And so there was basically a whole lot of reasons why engineers might have favoured the principal. And there was probably some engineers out there who didn't fully understand how to act independently, and this was causing some dissatisfaction. So in order to try and address this issue, the engineer role is gone, and it's now the roles that the engineer was previously undertaking have now been split into two. So on the one hand, we now have the independent certifier. So the independent certifier is going to be undertaking the roles that the engineer previously did when they were wearing their independent decision maker hat. So the independent certifier, as the name suggests, they've got to be independent and impartial, and they have to act fairly when making decisions on matters under the contract, including disputes. And the contract sets out the specific duties of the independent certifier and the various matters on which they can make decisions. So the duties of the independent certifier include valuing the work, deciding the contractor's entitlements, valuing variations, and considering and granting claims for extensions of time. And the independent certifier makes decisions where the parties can't reach agreement. So there's a number of places in the contract where the parties have to try and reach agreement, and that agreement would usually be reached between the contractor on the one hand and the contract administrator, who's the new representative of the principal, and I'll talk more about that role in a minute. But where the parties can't reach agreement, then the independent certifier steps in and makes an independent decision. So in terms of whether this is really going to make much of a difference, having the independent certifier instead of the engineer. It's hard to know. There's also a limit on when the independent certifier can act as an agent of the principal, and it's really in relation to payment claims and payment schedules, and the reason for that will be to ensure that Construction Contract Act requirements are met, so the independent certifier can still act as the agent for the principal for those matters. When the independent certifier issues decisions, they have to be in writing and include reasons, and I think that's good because that should help to ensure that those decisions have a good basis. Now, a really important thing to note here is that the contract administrator and the independent certifier can be the same person, so the contract specifically allows for that. And I think the idea here is that for lower value contracts, where perhaps the principal doesn't want to pay for both an independent certifier and a separate person to act as the contract administrator, they can use the same person. So this really gets us back to a similar place as we had before, where we had the one person acting for the principal on the one hand, but also being the independent decision maker on the other. So I think that does, to an extent, water down the benefit of having these two new roles. Something else to note as well is that the independent certifiers now have a relatively new professional body. It's known as the Society of Construction Contract Practitioners, and that might actually be quite important in ensuring that the independent certifiers understand the role that they're doing, and that the right sort of people are being appointed to this role. That body has a panel, so if independent certifiers want to be on the panel for this new professional body, they can apply and be assessed to, and they also have a code of ethics and a code of conduct. So that might actually be more important than the amendment to the contract in terms of ensuring that the independent certifiers are doing a good job. And I also think it's going to be important for contractors to insist that when the independent certifier is chosen, because they're named under the contract, and insisting that it is someone who actually understands what to do and they're not just going to favour the principal. So the contract administrator acts for the principal, so they take over the responsibilities that the engineer previously did in their capacity as the principal's agent, representative and expert advisor. They also give instructions on behalf of the principal. The engineer's representative that existed under 3910/2013, that's no more. They've now been removed and there's no more assistant to the engineer's representative either. And I guess that's a result of the new contract roles coming in. So the engineer's representative is no longer needed. Previously, they could undertake only some of the engineer's roles. There's also the introduction of the advisor role. Sorry. So it's always been the case that parties have appointed advisors to help them navigate the contract. So, for example, quantity surveyors, engineers, project managers, that sort of thing. But now the contract specifically mentions this. So it's 6.3.6 permits the principal to engage advisors. They can assist the contract administrator as well as the independent certifier in carrying out their duties. But it's important to note that the advisors, they don't have authority to issue instructions or they can't make decisions under the contract either. And so this is different to the engineers' representatives that existed previously. And another point to note is that both the contract administrator and the independent certifier are required to notify the contractor where they have appointed persons as advisors. So that's something to just bear in mind where advisors are going to be appointed, or it might be that parties want to delete that requirement from the special conditions just to save on admin time. The contract now differentiates between instructions on the one hand, so that'll be things such as design changes and decisions with a capital D. So that's things like valuing variations, assessing extensions of time, and other assessments made under the contract. The contract also now sets out factors that the independent certifier can consider when making a decision, and it's really just the things that you would expect them to consider. But I guess it's still helpful as a guide so that they know what they should be looking at. There's also a new review process set out. So this, the contract administrator, so the principal's representative and the contractor can try and reach agreement. That's always encouraged. If they can't reach agreement, then they can bring in the independent certifier to make a decision. So any party can request the independent certifier to review instructions by the contract administrator or decisions by the independent certifier. And so how this process works is that parties can request a decision from the independent certifier. If they're not satisfied with that decision, then they can submit further information or make further submissions and ask the independent certifier to make a different decision. And I guess this is kind of helpful because it allows the parties to work through the issues and try and get a decision that they're both happy with before they perhaps rush off to any formal dispute resolution processes. Or the other option is they can request what's called a final decision. So once the parties request a final decision and the independent certifier issues that final decision, that's it. The independent certifier can't then correct or modify that final decision other than minor things like typos or adding up figures wrong. They can only make those sorts of minor changes, otherwise the final decision stands. Where a party is dissatisfied with the final decision from the independent certifier, then there's a dispute resolution process under the contract. I'll talk about that later on. And there's no time bar for disputing those final decisions. And another option that the parties can always pursue is they can begin an adjudication under the Construction Contracts Act. So that's a statutory process that the parties can always resort to where they have a dispute that's arisen under a construction contract, including 3910. And because it's a statutory process, the parties can't contract out of it. So it's always something that is open to them. It's been quite a bit of kind of rejigging, moving clauses around in this contract, and one of the important changes is that the clauses around variations and various pricing clauses have all been moved into clause 9, so they're all in one section together, which makes sense. So for variations, the contractor and the contract administrator have to try and agree a value of a variation. So that actually was already in 3910, that the parties would try and agree. That's not actually a big change. In failing agreement, the independent certifier will give a decision on the variation with reasons. There's also a new provision that deals with final accounts. So there's both an interim final account, so that's issued following practical completion, and then there's a final account, which is issued following final completion. And so what the contractor can do is they can still amend the contract price after practical completion to include any variations or instructions that have been issued since then, and then those get included in the final version of the final account. So as per the collaborative approach that this new contract is supposed to embody, the parties have to try and agree the final account as far as possible. And the contract actually allows them a period of 3 months to try and reach agreement. I think that's quite a long time, particularly for smaller contracts. I'm not really sure if parties are always, particularly contractors, I'm not sure if they're going to be happy about waiting around for 3 months to try and agree a final account. And particularly if the principal is trying to drag things out. At the end of those 3 months, if they can't agree, then they can ask the independent certifier to decide. And the process also provides that the contractor will only submit their final payment claim once the final account's either been agreed or it's been decided by the independent certifier. So again, I'm not sure if that's something that contractors are going to be completely happy with as well. I'm sure a lot of them would prefer an interim payment, particularly of the items that have been agreed. Another interesting provision in the final account section is that it says that neither the interim final account or the final version of the final account can be payment claims or payment schedules under the Construction Contracts Act. And this is quite an interesting question because it's not actually possible for parties to contract out of the Construction Contracts Act. So if a party does ignore this provision and they decide they do want to submit a payment claim under the Construction Contracts Act, which has special requirements, and then they try and enforce that payment claim, I'd be interested to see how an adjudicator or the courts would approach this question. There's kind of different ways they could look at it. They might say, well, it's not a valid payment claim because the contract didn't allow you to issue a payment claim at that time. But on the other hand, they might say, well, the parties can't contract out of the Construction Contracts Act. So if it's a valid payment claim, then it's enforceable. So it's probably something that the parties want to think about in their special conditions and whether they want to be able to issue payment claims or not at the interim final account stage, and to deal with it that way rather than have this uncertainty. There's a couple of clauses that I want to talk about that deal with risk allocation, because that's another issue that was up for debate when this contract was drafted. So at clause 7, which deals with indemnity and liability limit, there's a new optional cap. So contractors can now cap their liability if that's agreed, and that would be recorded in the specific conditions. So the specific conditions are a table that form part of the special conditions where the parties fill in a whole lot of details that they've agreed for the contract. So where the parties agree, then they can record the maximum aggregate liability that the contractor is going to accept under the contract, or that can be limited to the level of any insurance policy if that's greater. And it's also subject to certain exclusions as well. So I guess this is a change that's driven by the fact that contractors are increasingly looking for ways that they can cap or limit their liability. Another change under this clause is that it's now made clear that the contractor's indemnity under the contract for loss suffered by the principal is now fault-based. So what that means is that if the principal suffers a loss because of the contract works, the principal can only seek an indemnity from the contractor for that loss if that loss has arisen because the contractor was negligent or breached the contract. So if the contractor carries out the contract works and they carry them out as per the contract terms and as per reasonable standards, so they're not negligent, but the principal still suffers some sort of loss as a result, the principal can't then ask the contractor to cover that loss for them. So that's understandable, because I guess if contractors are carrying out the works as they're supposed to, they shouldn't be in the gun for bearing any loss that arises. Another point that's relevant to risk allocation is the contractor's design obligations. So 3910 is not a design and build contract anyway, so the contractor shouldn't really be undertaking too much design, but it is common for the contractor to perhaps have some design responsibilities, and they might be hidden away in the specification, so they might not be obvious. So there's now a new clause that requires the parties to record in the specific conditions any parts of the contract works that the contractor is going to be responsible for the design of. So that's a really good prompt for the parties to work out what those items of design are that the contractor is taking on and record them in the contract so that they're not hidden away and forgotten about. There's also been a change made to what used to be called the advance notification clause, so it's now called early warning. And so previously this only placed an obligation on the contractor. So the contractor was obliged to warn the principal about certain matters that would materially alter the price or the time to complete the contract. So now this is called the early warning requirement now rather than the advance notification. And the obligations now fall on both the contractor and the principal. So I guess that's more of this collaborative approach of both parties sharing that responsibility once they become aware of something that might cause a delay. So either party has to give a notice in writing as soon as they become aware of anything which is likely to materially alter the contract price, delay completion of the contract works, or result in a statutory breach. And there's also consequences as well if parties don't do that. So it is important that they try and comply with these obligations. I'll talk a bit about the dispute resolution clause. So this is important because as much as parties try and avoid ending up in disputes, unfortunately it does happen quite a bit with construction projects. So the dispute resolution clause has been rejigged quite substantially. It's been made simpler. There's a requirement for parties to endeavour to resolve disputes promptly by negotiating in good faith, and in particular they have to have their senior representatives involved in that, and they need to do that before referring the dispute onwards under the dispute resolution clause onto the other options. Under the previous version of 3910, either party could require the other to attend mediation once they got to a particular point in the process. So mediation is now no longer mandatory. So the parties will only go to mediation if they both agree. And I guess in some ways this is quite surprising because it's not really in accordance with this kind of collaborative, cooperative approach that the contract is trying to embody. But on the other hand, if the parties are already trying to agree on a whole lot of issues and already negotiating, then mediation doesn't necessarily add a lot. And particularly if the parties have just reached a point where they're not going to agree, they need to go to arbitration, then sometimes mediation is not really worthwhile. It's also been clarified that any dispute can be referred to arbitration, subject to certain requirements where a final decision's been requested. So this is really something that's come out of case law. So there was a case a few years ago which said that the arbitration clause only was effective during the construction phase of the dispute. So once construction was finished and the engineer was no longer in their role, then that effectively meant that the parties could no longer require arbitration because they couldn't go through the steps that preceded arbitration first. So this is now clarified that arbitration is always the option that the parties go to where they can't reach agreement in another way. And the other thing to bear in mind here is that adjudication under the Construction Contracts Act will always be available to the parties because it's a statutory process, they can't contract out of it, so that's always another option for the parties, and it's relatively quick as well. If they have a dispute that they can work through in a few weeks or months, they can send it off to adjudication. There's various other updates and changes that have been made to the contract as well. So a lot of language has been updated to make it a bit more straightforward and easier to follow. Some of the terminology has been changed to better match terms that are used in the industry. So the old contract used the term on-site overheads, and that's now been changed to preliminary and general, or P&G, just to match up the terms that people use more commonly. And off-site overheads and profit is now called margin for the same reason. I also had a question come through from someone about the specific warranties that are provided under this contract. So the warranties and guarantees section hasn't really changed. It has been rejigged a bit to include both the warranties and the guarantee in one subsection. And there's been some minor changes made to Schedule 13, which is the schedule used when parties are giving a warranty, but other than that, the warranties section hasn't really changed. In terms of what specific warranties will be provided, that's something that the parties agree at the outset and record in the contract. So there's not really much change in terms of warranties and guarantees. They're just whatever the parties agree will be provided. I note there's also a protection of the environment clause that's been included, and I guess that's also just signifying that that's something of increasing importance to parties that they need to be thinking about in terms of the contract works. So in terms of what the parties need to do now that this new contract has been released and it's being used in the market, there are quite a number of changes that the parties need to get familiar with. So if you've got staff that are going to be working with the new contract, they're going to need to have a good understanding of what these new processes that they're going to be following. So particularly for variations, extensions of time, the new review process, and they're also going to need to understand the new roles, so that the engineer to the contract has now gone, and instead there'll be the independent certifier and the contract administrator. And they'll also need to get familiar with the new terms used as well. So there's going to need to be a bit of training going on, either formal training or parties just reviewing the contract themselves. Another thing that parties are going to need to do before they start working with this contract is get any special conditions that they've been using updated. So if you've got template conditions that you use with 3910, any conditions that were working in with the 2013 version are not going to work anymore, because there's been changes of roles, changes of language, and a lot of clauses have moved around as well. So they're going to need to be updated and rejigged as well, and that's going to take some time. So you'll need to get on to reviewing and updating those. And it's important that parties get onto that fairly promptly. You don't want to be leaving that till the last minute when a project arises. And in terms of the special conditions, even though the contract is reasonably comprehensive, there's still going to be additional clauses that parties want to add in via the special conditions. So commonly parties want to add in, say, a confidentiality clause or something about how media statements are dealt with. So that's a common thing to add into the special conditions. The general conditions don't include a force majeure clause, so often the parties want to add one in, providing what the process is, if there's like an act of God or another major event. And of course, a lot of principals will have their own requirements that they need to impose, or site-specific requirements as well. So all of those need to be incorporated into updated special conditions, and that all takes time, and some advice will be needed a lot of the time as well. I'm just checking if anyone has sent through any questions. We don't seem to have had any come through. So unless anyone has any burning questions, then I'll probably bring things to a close quite soon. So I haven't had any questions come through at this stage, other than the one submitted earlier about the warranties and guarantees, which haven't really changed. So I think that probably brings us to a close. I hope that was helpful today in understanding what the key changes are. If anyone needs any advice or any assistance with drafting updated special conditions, then please get in touch. We'll also send around a recording of this webinar, so you can share it with anyone else who you think might like to see it, and all the best in working with the new contract, and thank you for attending today. I hope it's been helpful, and I'm going to leave it there.